right, good morning. This is Senate Judiciary Committee. It is Thursday, March 10th, 2020. And first order of business is S-268, and act relating to the right to farm. And we've had a number of people testify on the bill. I was requested more testimony, but I can only tell you that hopefully we can finish this off. Our crossover deadline is tomorrow at 11 a.m. So we have to have any bill that's going to make it out of the Senate Judiciary Committee has to be completed by tomorrow at 11. So I'm asking that people keep their testimony brief so that the committee can have some time to work on the bill. Because we have 4 other bills that we have to dispose of in one way or another in the next couple of hours. Today and tomorrow morning, we have brief time. So with that, our first witness is Travis Samuels with Zion Growers. Travis, welcome to Senate Judiciary.
Good morning, everyone. Thank you for having me. So I will try to keep it brief. As you said, my name is Travis Samuels. I am the COO of Zion Growers. We operate out of St. Johnsbury, Vermont, and we are a processing company for industrial hemp. As most of you are probably more familiar with CBD, industrial hemp is the cousin, but it's more standardized crop, a row crop closer to corn or hay. So I was kind of given some information on the bill, and I've kind of read over it. And based on what we're doing directly, as we're trying to assist farmers in the transition from traditional crops and looking to help them diversify what they're currently doing, this is something that is really important to kind of allow them to openly grow this crop. I know there's a lot of issues around, the smell and kind of what people think in the area as far as growing it in their area. So allowing farmers to do something like that, for me as a processor who's out there talking and cold calling farmers to try and get them on board, this is something really important to know that they have the backing of the community and the state legislature to basically say, you can grow this without worrying about what might come from your neighbors and things like that. So, this hasn't changed in the last 20 years. This is a law that really should be updated, and it's, not necessarily as strong as some of the support other states give to their farmers, making sure that they do have certain protections to allow them to continue their farming practices in a way that they've been doing for a very long time, and ensuring that they can continue to operate as they have been operating within the bounds of the law, without having to worry about, people moving in or people getting upset about the way that they're going about their traditional farming practices. I know that this will protect farmers, but it won't necessarily step on their toes as far as full suits, but it'll give them additional protection to make sure that their neighbors won't, if the neighbors lose the suits, that they will be required to pay the legal expenses of the farm, which is important because if the farmer, given the, the shoestring budget most farmers work on, that's something most of them cannot afford, especially the ones I've talked to. Gas prices going up, fertilizer prices going up, and this applies to farmers across the board. This isn't something they could afford. This, a lawsuit is something that could potentially sink any given farm. Things are already highly regulated as far as agricultural practices, water quality practices, and things like that. And, those protections should be in place. Those regulations should be in place. But we need to make sure that if we are asking farmers to do that, that we do give them protections to make sure that they don't have issues moving forward if they are following the law as it is written. They're doing what they're supposed to do. Pardon me. As far as from the ag industry as a whole, this is something that I think they can all get behind. Me, as someone who's grown up in St. Johnsbury, I was born in Hanover. I live in Barnet, Vermont. This is something that affects me and all of the community around me. People I went to high school with, people I currently know who are trying to make a living in the agricultural industry. This is something that, from the people I've spoken to, they really support, knowing that they will have the backing if push should come to shove, in kind of what they're doing in their agricultural practices. From my understanding, the bill wouldn't supersede any suits or violations in process. And it seems to me that it needs to be updated from what it currently is to ensure that these farmers have protection so that Vermont can continue to be an agricultural state and kind of move forward as such. I know, we don't want hundreds of acres to be kind of divvied up all over the place just so farmers can continue to work and operate, and kind of giving up the backbone of what is Vermont from an agricultural standpoint. I think that kind of covers most of the feelings and thoughts that I have on it. I just know that as we're trying to get farmers to move over to a new crop, something that's a little, complicated, it's a little uncertain for them, having this kind of backing, especially knowing that they're moving into something that someone might have an issue with them growing, that they'll have some kind of support, I think is very important.
Thank you. Are there questions for Travis?
I have a question.
Senator Nick has.
I'm just wondering, have you had any experience? I'm not sure, you're a grower, so have you had any experiences with people complaining about your fields or, your business?
Personally, no. Growing out in Barnet, I have a very large presence between me and my family in the town, and we are very open and honest about what we are doing. And we make sure to talk to our neighbors. We make sure that they understand what's going on. I do know of people who have had an issue. So it's not to say that it doesn't exist, but for me personally, I have not been affected.
Thank you.
Thank you. You spoke about the protection from nuisance lawsuits that basically the loser pays, as I understand that. If the defendant prevails, the court will require the plaintiff to pay the actual amount of costs and expenses determined by the court.
Correct.
But if am I correct, if the farm wins, they get.
That's correct.
What if the
plaintiff, that is not recognized as an award in the bill.
Thank you. Isn't it normally?
Not necessarily. For example, in the Public Records Act arena, if a public agency withholds a document and a person who requests the document litigates and wins, they get attorney's fees. But if the municipality, the public agency wins, they do not.
Okay. All right. Thank you. All right. Any other questions for Travis? Thanks so much for joining us this morning.
Of course, thank you for
You'll
having
be
me.
able to join us in person if you need to.
I would love
next-
to. I think this is very important, and I'm glad to see that there is some support for it and that it's moving forward, at least in this capacity.
Thank you. Rusty Rumley is a senior staff attorney with the National Agricultural Law Center staff. Welcome, Rusty.
Hi, thank you for having me here. So one thing I do want to point out, I do not have any testimony to give. I was asked to be on here just solely as a reference for questions. I deal with right to farm statutes all across the country on a pretty frequent basis. So that's the purpose of me being here today, is just to serve as a resource. Like if you have questions about how other states have done it, recent changes that states have made, things like that. But we can't advocate one way or another for any piece of legislation.
Okay. Well, thank you. Maybe since you are a resource, I would ask, these mask things are problematic because I'm trying to eat a muffin. Well, do you have an answer for that? Rusty, one of the questions that comes to mind here, how does this compare with other New England states?
The current,
For example, Maine, particularly Maine and New Hampshire, which are the northern New England states.
Yeah. So the northeastern states are a little bit different from the rest of the country. This current version is probably a bit more on par with what New Hampshire has. Maine is one of those states that they do it partially by agricultural areas that are zoned. New York kind of follows that same approach. It's a little bit different than what the rest of the country tends to follow, but 268 is probably a bit more closer to New Hampshire than what you currently have in existence.
You know, if New Hampshire's law provides for the loser to pay, whether it's the farmer or the person bringing the nuisance suit?
It does not. I can think of roughly 15 or so statutes that deal with attorney's fees. It's been more of a recent trend to put that kind of language in there. Florida passed amended their right to farm statute last year and has a very similar provision for attorney's fees in their bill. And I know Texas and Oregon also have similar language. But attorney fees provisions can vary pretty substantially across the country.
Thank you. Yes, Senator White.
Thank you. So I'm just curious if, because one of the things that I think we see is that there's a lot of, maybe not a lot of actual suits, but kind of more harassment. And have you seen in other states that have this protection, there's less harassment because there's less understanding? Or, I mean, it seems to me that what we heard was there's a lot of stuff that doesn't rise to the level of a suit, but that is just harassing your neighbors because their pigs smell or whatever.
So this is one of those things that's really hard to quantify. And I actually had the same question come up from the Vermont Senate Agriculture Committee last year on an agritourism statute. When you get into these state level complaints, especially ones that end up being lawsuits, the only way I can find these cases through legal research is if you have a lawsuit that's filed, it goes all the way to a final verdict, and then that verdict is appealed up to like the Vermont Court of Appeals or the Vermont Supreme Court, and they render an opinion. And at that point, you can find it through legal research. But before that, I mean, it's pretty much all you can do to do your research is word of mouth, things like that. Sometimes some of the insurance companies, if they've had to get involved to pay for an attorney, they might have a little bit better grasp on the statistics of how often these things move forward, but it's a really difficult number to pin down. Sorry, that's probably not the answer you wanted, but it really is a pretty nebulous area.
It wasn't what I wanted you to say, but thank you. I wanted you to say that it stops all harassment.
So with these types of lawsuits, you're generally dealing with, one neighbor fighting with another neighbor. And I mean, legally speaking, these are some of the nastiest fights you can get in. I mean, the nastiest is usually one spouse fighting against another spouse. But then, it's kind of the step down is one neighbor going against another neighbor.
Yeah. Thank you.
I was wondering, could you elaborate on the zones that you mentioned in some of the other states?
So those are, you see it a little bit more in the Northeast where states have been in existence significantly longer. And you have more of the state, you have zoning boards or county zoning boards that have gone in and designated specific agricultural areas. So in some of those states, they'll go in and say, well, right to farm will apply in these areas that are specifically zoned for agriculture, but it may not apply in other areas. So that's typically what I'm talking about when I mention those agricultural zoned areas. New York has a right to farm statute. It is extremely long. I haven't looked at it recently. I think it's somewhere in the neighborhood of 40 pages, single spaced. I think where your current bill is 8 pages, double spaced. It is a beast to get through.
Well, they're a paid legislature, so they have more time.
They get paid by the page.
Right. You've raised some interesting issues for me, but I know on most things in my area rely on zoning. Certain commercial things are allowed, certain other things are allowed. And I'm not sure how Vermont really does that. Although we really don't have.
We don't.
Do we have any?
So municipalities have the ability to designate areas as agricultural districts, but it is largely ineffective because municipalities are also exempt from regulating zoning and regulating farming through zoning. So you can say this is an agricultural district and then try to provide benefits for farming in that district. But the municipality can't zone and or regulate most of the farm's activities. So most municipalities don't exercise that authority.
This is Mike Grady, by the way, who's legislative counsel on agriculture issues and a number of other like natural resources and other issues. So, thank you, Mike. Other questions for Rusty?
Thank you.
Okay. We were gonna, thank you, Rusty. Appreciate
You're
it.
welcome.
We were
Yep.
gonna hear from some developments, but he's not here yet. Is that?
I haven't seen them.
Well, our next witness is Michael Grady, so why don't we wait for Sam and have Mike start?
Can I just throw in an observation?
Sure.
First of all, this is the first time I've been looking at you guys and being able to say, hey, can I say something? I know, it's right, exciting. But, so I just saw the headline and I didn't read the whole story, but some town prohibited them from having, anybody from having chickens in the village area. Some town, I mean, my God, because they didn't like the roosters in the morning.
So
Anyway.
I can address that if you would like.
Yeah, I just,
Yeah, I'd like to hear it, Michael. I was just gonna say in response to Jeanette, that my wife and I lived in our house, which is on a hill. There's a valley between me and the next hill. And we lived in that house for 15 years before this neighbor came in. He decided he was gonna have chickens. Well, he built the building. It's about 2 football fields long and has over 600 chickens.
Oh, my God.
Which by itself is fine. The problem is every summer, if he doesn't apply the appropriate pesticides or whatever the case may be, our house becomes inundated with flies.
oh, yeah.
You can't sit out on the deck or in the yard because you're just inundated by flies that are flying up your nostrils as you're trying to breathe.
Oh, God.
So I'm looking at this piece of legislation going, how is this going to impact me? I'm tending to be somewhat careful on how I vote here, but
Well, how would it impact you and others that
600.
when the nuisance came to you versus the
yeah,
you
I
came
was
to
there
the
first.
Well, that, you would have to, all of these, and Mr. Romley can weigh in on this as well. These claims and protection under these laws are very fact specific. Because the conditions for the protection are largely about whether or not the activity is changed, if it's changed unreasonably, if you're complying with standards established by the State Agency of Agriculture, if the practices you are involved in or engaged in are in industry standard. So it's very fact specific. So to say, oh, you have a claim against him or he came to the nuisance or not, you have to look at the facts and apply it to to the law. Under the existing Vermont right to farm, he probably does not have the protection of the right to farm because he doesn't qualify for all of the conditions. And specifically, the one condition that he would not qualify for was it is established prior to the surrounding non-agricultural activities. So that is under the existing Vermont law. If you look at the facts of your situation, that farmer likely does not qualify.
Does this change that?
It may, because there is a condition in the proposed bill 268 that the farm operation existed before a change in the land use or occupancy of land in proximity to the farm. So that would not qualify. But there are other conditions in this bill that the farm would qualify under. For example, if they're in good standing with the Agency of Agriculture under the water quality section, that would probably qualify your farm, that farm, the neighboring farm, for the protection.
Would he be in good standing with the Agency of Agriculture if he's letting flies inundate the neighborhood?
So this is only under 6 VSA Chapter 215. That's the water quality chapter. Not there really isn't a law regarding for that size farm for odors, pests, vectors, and other types similar activities. A large farm does have requirements for that. But a 600 chicken, how many chickens do you think?
It's in excess of 600 chickens.
Right. Well, so a certified small farm is 2,250. So does he have more than 2,250?
He said no.
No.
Yeah. So that he's still a small farm. He's still not subject to any specific provisions about odors, noise, vectors, and similar.
Can you help me? Oh, thanks so much, Peggy. Appreciate it.
Oh,
Mike, maybe you could help me in better understanding how this bill would impact, rather than using Joe as a neighbor, for example. But, next to me is farmland. The only thing they do with that farmland is hay. So obviously there's nothing problem. But up the road a piece, somebody just put in goats and other animals, but they're not big farms, so they're not covered. I mean, they, if somebody took this farmland next to me and decided to have chickens or goats or whatever, does that automatically, I mean, because of the size of it, it's going to be a small farm. Or plant hemp, does that automatically, if this bill passed, take my right as a neighbor from complaining about that change of use?
So it could. Again, it's a fact-specific analysis, but it could, because one of the things that is being allowed here under this bill is a change in the type of farm product being produced. And so if you were haying as a farm and then you brought goats on, that's a change in the farm product that's going to be produced, and that would be protected. You would continue to have your protection as a farm. And part of the reason for this provision from Senator Parent's point of view is that the Agency of Agriculture, the General Assembly, is advocating that farms diversify their income sources so that if there is a down year in milk or a down year in maple or a down year in beef, that there is some other income that helps support and or stabilize the farm. So if you're, as a state agency and a state legislature, advocating for farms to bring on new activities, but you're not giving them the same protection that they had as farms prior to them bringing on new activities, it's a bit of a, they find themselves potentially in a catch-22. Do I bring on a new activity and potentially aggravate my neighbors, or do I not diversify and maintain the same level of relationship I have with my neighbors? It's a difficult situation.
Yeah, it is. This is a little more complex bill than it seems at when I first look at it, because hemp does have an odor to it, and Travis mentioned that. So, and most hemp growers are changing use from some farmland, I'm presuming, because they, it wasn't grown before. I know I'm out in the Hallett, Rupert area where I represent part of that district, some of the richest farmland in Vermont, and a lot of folks have gone to hemp. And frankly, when you drive by, the odor is obvious at certain times of year.
Certain time of year, yeah.
Wouldn't bother me when I'm driving by, but I wonder about, and all the neighbors are farmers, so I'm sure they're not complaining too much. But if that goes into a residential area, which happens to have a little bit of farmland, I can see my neighbors saying, "Why did you vote for this thing?"
So what happened at the high school my daughter teaches at here in Vermont, there are hemp fields nearby.
Yep.
And so the school says, well, during certain times of the year, we can't tell if kids are smoking marijuana in the hallway or the bathroom because the whole place smells like marijuana anyway. So, I mean, they aren't complaining to anybody, but they said, geez, this did make some kind of a difference here.
I wonder, Rusty, if you have any comment on this discussion about Vermont's pretty clear. If you come to the nuisance, that's your problem, that you smelling things from the farm or odors or whatever else, as long as they're following the law.
The current, sorry.
No, go ahead.
The current version of the Vermont statute, if they come to the nuisance and you're in compliance with all federal and state laws, and see what else is there? There's several things that you have to do consistent with good ag practices. You have to be established prior to the non-agricultural activities. If you do all of that, you get a rebuttable presumption that you're not a nuisance. But it does not. It is not a straight coming to the nuisance. Your case will be dismissed if the farm was there first. It merely creates a rebuttable presumption that the plaintiff would have to work to overcome during a trial.
That's correct. And that's one of the things that the farming community is, when they look around the country and they look at other states' laws and they see that the protection for coming to the nuisance or other types of change in activity is just provided if the facts apply to the law, they feel disadvantaged. And that's one of the reasons why the bill has so much support in the current farming community, because they think that they are on the low end of the spectrum of protection of the right to farm laws in the United States.
This is very helpful to me anyway.
So, there are other issues that, I was trying to think of three things just popped into my mind about your chickens, that it's at a particular time of the year and not all the time. It's at a
Right.
So I live in the village of Putney, and the paper mill we have a paper mill right in the middle of the village. And periodically, they do something, I don't know, I mean, it used to smell all the time, but now they have better cleaning in their stacks and stuff. But periodically, they have to do something, and I don't know what it is that they have to do, but they have to do it about once a month. And it stinks to high heaven. But that's, you know, we put up with it because it's something that is there and it needs to be there and it provides jobs and it does something. And the other thing I thought of was my office that I used to work in was right near a coffee roaster. And in my opinion, there is no smell worse than coffee roasting. Not the brewing of coffee, but the roasting. It has a very metallic, like burning plastic, I think. And the third thing I thought of was we had an author who had a beautiful place out in the country, and there was a what do you call where they bring down the logs when they're logging and then they bring them down here to
Skidder trail, yeah.
okay. And he was outraged because it made so much noise he couldn't write.
Oh.
And it was, and that's how he earned his living. But he couldn't write because it made so much noise. But it wasn't all the time. It was at times of the year. I mean, it was when I was on the select board. We told him to just suck it up and live with it. But I mean,
Is that why he moved?
I mean, it isn't just agriculture. There are lots of things that impact our
Quality.
and the enjoyment of it. And if it's constant, if it's every single day, every hour, then I think that there's a reason for complaint. But I have real problems when we, we told him that if he really objected, then he should buy that whole wood lot and not let them log, but
In the case of an infestation of flies, though, Michael, the bill retains the provision that says the state or local public health entities can come in and abate a nuisance that affects the public health.
Yes, yes. So the public health authority at the state level and at the municipal level remains. If there's that public threat, what is called the public health hazard under Title 18, the state or the local health authority, which is often the select board, can act to try to mitigate that. Anecdotally, what happens is that the select board meets with the farmer to try and mitigate that. They bring the agency of agriculture in to help provide guidance on what the farm can do. There are things that can be done prior to litigation to try to address those issues.
You ever seen the infestation of flies become in the case these are fact-specific situations, have you ever seen an infestation of flies be labeled as affecting the public health?
I have. It's not necessarily flies. The term is generally vector or pest, because when you have that type of issue, it's usually not just flies. So it's been used for pests and vectors. Yes. There was an issue not far away from here in a composting facility where there were vectors.
Yeah.
And the agency required vector mitigation because the vectors were encroaching into residential neighborhoods.
great fun when you're sitting on your deck and you go to say hi to your wife or whatever, and all of a sudden flies are flying in your mouth at the same time.
Yeah.
It's gotta be terrible. See.
There's the one that doesn't work. Anyway, so thank you, Rusty. Appreciate it very much. One thing that answer my text here must be extremely important. What does this do more than the rebuttable presumption? I mean, what, does it go beyond that?
Well, first, there would be no more rebuttable presumption. That if the conditions for protection apply, then the farm, the agricultural activity would receive the protection from nuisance suit if you apply those facts to the conditions and they were satisfied. There would be no opportunity for the neighbor to say, even though the conditions are satisfied, you should not provide that protection because of X, because of whatever condition you would provide for a rebuttable presumption.
So in order to deal with the neighbor who changed the use of his or her farm, as long as it's legal, whatever it's doing, one would have to find there's some agriculture practice, just practice or whatever you call it.
Well, right, you would need to look at the conditions and the activity. I do want to be clear that this is a nuisance protection suit. It doesn't protect trespass. It doesn't protect negligence. It doesn't protect violation of water quality or other state law. This is nuisance. And only that. Other states do provide, some states do provide, and Mr. Rumley could probably find more on this, on trespass and on negligence. I don't think that there are that many that do, but there are some states that do provide that type of protection. And then there are some states like Oregon that are like, I think you either have to cause a death or you have to harm the agricultural value of a neighboring product in order to not qualify. And so I do think there are other more stringent laws out there. This is just nuisance. It does not affect trespass, does not affect state law, including water quality.
Okay, so there is a case, there's been 2 suits in 30 years, is that correct, in Vermont?
Again, to our knowledge, that there are potentially causative actions that have been brought, but then settled or dismissed or withdrawn, and that's not going to show up in the court records that are easily researchable.
When you speak of that, does one of those involve the pigs on the Stowe access road, on the road to Stowe Mountain?
What was that?
A person who, something happened, they were very dissatisfied, so they put in a pig farm next to like a restaurant or something, so they were very angry about something, and that went to court.
I'm unaware of that. When did that happen? Was that recent?
No, a long time ago.
The case that's most referred to as Trickett's versus Ox, and an apple orchard that changed its packing processes, and allegation that it was causing noise at inappropriate hours. And then the court found that the farm did not satisfy the protection for right to farm. And then you as a body amended the law
Yeah.
to say that a farm of that type would receive that protection in the future.
That was an Orwell case.
Yes, yeah. And then there's the very recent case. In that case, though, that is the full suite of allegations. It's not just nuisance, it's trespass. It's also an allegation of violation of state water quality laws. I do think there might be a negligence claim involved in that as well, but I have to review the complaint again.
Question. Yep, Senator Bennett.
Michael, I'm reading page 6, the 3 categories by which farm cannot be found to be a public or private nuisance. If they are afoul of 2 of those 3, but are in fact compliant with 1, does that mean they can't be found to be a nuisance?
As this bill is drafted, it's 1 or more of the following. So if they qualify for 1, they receive the protection.
So if they've fallen out of standing with the Department of Agriculture,
So
and yet they meet the other 2 criteria, they are protected?
yes.
That's an interesting.
The fact that a farm is not in good standing is underwater is rare.
I don't know what the standing status would be if they're letting flies into the neighborhood.
That's not a water quality violation.
Right. So I'm assuming then that they are going to be in good standing with the agency.
For water quality. They're only, in the past couple of years, there's only been between 2 and 5 farms that have not been in good standing at any one time. And normally that inspires a farm to get into good standing.
But most farmers are in good standing with the Agency of Agriculture.
For water quality, yes.
So that does bring up a question for me, is that it's only the standards for water quality, but if they are not in compliance with other or in good standing for other in terms of other issues, then how does this impact, or where does that fit in? Or don't we regulate them?
For medium and small farms, it's largely it's not going to apply, because medium and small farm permit, the medium permit and the small farm certification, and then the RAP requirements for small farms, they are largely just water quality. The large farm permit, which is a water quality permit, does have more than just water quality requirements. So that if they were complying with that, they would receive the protection. Now, it doesn't need to be one of the triggers for protection, or you could say it has to be all of the following, not just 1 or more of.
So I just have to say that farming is way more complicated and impacts people. I'm thinking of, we have a large farm on the flats in Westminster, and they, for a long time, it was pretty smelly down there, and they started composting their manure, and they're providing enough electricity for, I think it's 150 homes. They're drying out all the manure and using it for bedding. I mean, it's really, and yet people still whine and complain because periodically it does smell, not all the time, but,
I agree with you. The complications are really interesting the more I think about this, because in the case of a fly infestation, if I read this correctly, in my circumstances, this farm was not there before I was. So you brought that in, it doesn't get protected under item number 1. The question then becomes, have I brought a suit within 2 or more years or not, prior to the date the nuisance action is commenced? I still haven't thought that through. But assuming he can't get protected by that, he can simply get protection if he's in good standing with the Department of Agriculture, or the Agency of Agriculture. Yeah. And I'm struggling with how that all fits together, and why would we want to not require all 3 of those to be in the umbrella, as opposed to just one of them.
but couldn't you go to public health and
Public health might be able to shut them down, but I can't sue them for nuisance if that's the way that
Well,
it.
you can sue. Remember, this doesn't take away your right to sue. It dictates how the court is going to, if the facts apply to the law, how the court will find.
One thing that it's
Also lose if you don't prevail.
one thing that is tricky with the first one about which one was there first, and we've seen this issue towards the East Coast, where farms and houses tend to be a lot older, is you may have a farm that was established in the early 1800s, and there are neighboring houses, and you don't know when they were built. Could it be early 1800s? Could be late 1700s? And trying to sometimes pick, which, or trying to clarify which one was there first can be tricky. So that is one thing that we've seen. How do you define who was there first? Does it have to be the current occupant of the house has to be there first? What if it's an ancestral family home and that same family's lived there for the last 200 years? Is that sufficient? Or are you looking, was the structure for the neighboring house built before the barn that the farm is currently working on? Which, how do you establish which one was there first? That can be tricky. And that has been an issue in cases in the past.
Rusty, I'm just going to play this out with you. In the case of this particular farm, it was a farm prior to the Civil War. The land that I live on was also a farm, but the triggering device here shouldn't be the question of whether it was a farm. It should be a question of what the nuisance was that you're now talking about. Because for 150 years, it was a dairy farm. Now it's a chicken farm, and it's the chicken farm that's causing the difficulty living in the neighborhood. So shouldn't we be questioning the point of nuisance, what the creation of that nuisance was, as opposed to just saying it was a farm before you got here?
You can. I mean, there are states that do that. For example, in the state of Texas, the way they do it is kind of a novel approach. They will say, if a farm's been in existence for at least a year, it's protected. But if they add a new activity, so there's a change in the farming operation, that particular activity is not protected until that statute of repose passes. So like in your current version, you've got a 2-year statute of repose, if the farm's been in existence 2 years prior to the date of the nuisance action. So like in Texas, there was a case a couple years ago, they have terrible problems with feral hogs tearing up crops. So it was a farmer that was raising row crops. Hogs were getting into his field. The farm had been in existence for years, decades. That wasn't the issue. And no one minded the farmer raising crops. The problem they had was when he brought in a propane cannon to scare away the hogs. So that thing, went off every 15 minutes, 24 hours a day. And so the way Texas dealt with it is if there's a changed condition, that changed condition is not protected for that statute of repose. Texas is a 1-year period. So anybody can sue concerning the propane cannon for that first year. And someone did. I mean, it didn't take very long for that lawsuit to get filed. So the farm itself was protected, but the use of the propane cannon wasn't. And they said, no, you got to shut down the propane cannon. That's too much of a nuisance. But if the propane cannon had gone off for a year and no one complained, then it would be protected.
We had that actual situation at an apple orchard in Bennington.
Yeah, with deer.
Trying to scare away deer
Mhm.
or eating.
There's a remarkable amount of variety across the country when it comes to these right to farm statutes. I mean, they're getting now 40 to 45 years old, and states have really taken to adapting them to fit their specific situations.
I sense the need for an amendment, Michael. Fair at least. I'm not sure how we're gonna get that out by 11 o'clock tomorrow morning.
Yeah.
Mr. Chair,
Having said that, Mr. Chair, Travis, who's still on with us, is one of my constituents. I want to support him.
Well, I don't know what happened to him.
He's still there.
Oh, Travis, yes, I'm sorry.
I'm still here.
Hi, Travis. Do you have any comments on this discussion?
Yeah, I do. Funnily enough, I have where I live in Barnet, we are right on, the river. And there's a chicken farm that actually started up in what used to be the old Butler dairy farm. So, I live up on the hill. I have the same problem with flies. I have the same problem with the smell, the chicken smell. And personally, from the way I kind of look at it, it's, what would I rather have? I look at it two ways. I've lived in a lot of parts of the country, and I've lived in cities. I've lived in the country. Obviously, I live here now. And it's what would I rather have? I'd rather have that farm there. If it's a slight nuisance to me, yes, with a smell, it's really only during one time of the year. I appreciate the fact that Vermont is an agricultural state. It's part of the reason I like living here. It's part of the reason that I enjoy the state the way it is, which I'm sure many people feel. So, there are things that come along with that. It's really a trade-off. You live in the city, there are going to be terrible smells there. That's the nature of living in a place like that. If you want to live in Vermont, the chances that you're going to have to deal with agricultural issues. I got stuck behind a skidder this morning on my way to my office. It's part of living here. It's part of the way things are. In my personal opinion, there are certain things, like he was saying, the cannon for hogs, that's egregious. That's a step in the wrong direction. There are other ways to go about it. But I think on the whole, if you want to live in a community such as we do, and you want to continue to be an agricultural state, these are things that are going to happen. You're going to have, smells. You're going to have certain nuisances that come along because it's agriculture. That's what people have to do to protect themselves, to protect their crops. And as we are talking about the diversity aspect, things aren't working the way people have been doing them for the last 100 years. The reason people diversified into CBD is because what they were doing was not working, and they were having trouble supporting and sustaining their farms. So to say that, we want you to be a farm, but we don't want you to grow X, Y, or Z, which really only leaves A, B, and C, which aren't working in the first place, you really don't leave them any options as to how to continue as a farm in in 2022. You really have to look at it, in my opinion, from what would you rather do? Do you want more developments, or do you want to continue to allow farmers to operate being farms on hundreds of acres of land? Because this is what it requires. These are things that it requires to be an agricultural state. And I think from Vermont's history, from the way things have always been done, that you kind of have to accept it, unless you kind of want things to go in a very different direction. And I think we all enjoy kind of the peace and quiet. I enjoy, you know, I can't see any of my neighbors. I really enjoy that from my standpoint. Does that mean I have to live next to a chicken farm? Yes, but it allows me to continue living in an agricultural state in a setting that I truly enjoy. I love living in the woods. I love being able to take my dog on walks, you know, through the woods without issue. It's, you know, a certain benefits that come along with living in a place like this that I really can't stress enough that will change if we don't give farmers the ability to diversify their crops from what they are now. Because as I said, things are not as they used to be. Dairy farming isn't as profitable as it used to be. You know, even haying, most people just hay their hundreds of acres for tax purposes because there's no way for them to really overcome that hundreds of acres tax burden unless they do something different. So I think, you know, there are nuances to the discussion about who can be, you know, sued and what that suit looks like and, you know, what is considered a nuisance. But I think on the whole, you know, these kinds of things, these kinds of issues are just what comes with the territory of living in a place where a lot of people farm. There are hundreds of acres of farmland. This is what living in Vermont is. You know, flies, excessive amounts of flies,
Travis,
totally understand.
I just want to interrupt you, Travis.
Sure.
I tend to believe I like both. I like to be able to enjoy farms and keeping agriculture in Vermont. I support that activity. The issue for me right now is I know there is a way to correct the fly problem, but occasionally he's just not doing it for whatever reason. And I want to figure out how can I actually correct that through litigation if he keeps that up. Right now, if I understand the bill correctly, the only way I could is the Department of Health or some entity would have to do it for me. And I'm not sure whether or not I'd be successful in having that done. So where can we reach a compromise so that I know this individual can be held accountable if he's not abiding by proper agricultural behaviors that would enable me to be assured I could live next door to this. I could put up with the smell every once in a while. That's not a big deal. But to literally be driven off of my back deck because of his failure to correct whatever the problem is, that's just not fair. And I think there's got to be a way to strike a happy medium here. I'm not sure how we get there.
Senator Baruth has a way.
No, Senator Baruth does not have a way, but I would like to just jump into the conversation. You know, I started in the legislature on the Agriculture Committee, and I was there for a couple of years. And one of the things that struck me is that there are many, many, many protections in the law for farmers. It's listening to the testimony, you would have the feeling that our laws are weighted against farmers and they're constantly laboring to protect themselves from our predatory laws. Farms have all sorts of built-in protections, almost amounting to a kind of sovereignty on the farm. So, you know, I come at this from a slightly different perspective, which is that there is right now a rebuttable presumption which makes it much more attractive to be the farmer in a potential lawsuit than to be somebody challenging a farmer. So there are all kinds of robust protections for farms, as well as incentive programs to help farmers. We're working on a multi-million-dollar package to help ensure dairy prices right at the moment. And that's, you know, part and parcel with what we do every year for farmers. So anybody watching this might think that the legislature has been remiss in protecting farmers. We have not. But what this bill does is it basically says that the farmer cannot be sued for a nuisance, all things being equal. And, you know, I go back to what we were talking about yesterday with the objective grid that the Department of Corrections was proposing and removing judicial oversight. I'm not convinced that we need to go to a state of affairs where a judge looks at a fact pattern and says this suit cannot proceed. Obviously, you don't want frivolous lawsuits, But on the other hand, Joe has talked about one situation. I can imagine plenty of others where people have genuine complaints about nuisance, and I'm not convinced by the idea that Vermont is a place where a farm should be able to do whatever it wants to do, regardless of the impact on the neighbors, because we support farmers. I think we have perfectly adequate supports for farmers now in the law with a rebuttable presumption. So I'm not inclined to vote for this bill, and I want to just put that out there so that people don't misunderstand and expect my vote when the vote comes.
So I grew up on a farm, and I know that farming has to constantly change, and that farming isn't a pretty thing. It isn't. Farming is harder and more complicated than making legislation, I believe. And what I fear is that people support agriculture, and Vermont is a kind of a cute, nice agricultural state. And what I fear is that what many people really want is kind of an agricultural theme park, not the reality of farming, which involves smells and noises and awful things and slaughtering and just things that people don't want to acknowledge. And so I really fear, I don't know that this is the answer, but I really fear that what is going to happen is that we're going to become kind of this cute agricultural theme park that people from the city can come up and visit and say, oh, isn't that sweet? And they don't have to smell it or see the dirt involved in it and everything else. So I think we do have a lot of protections for farmers, but I'm not sure that as our population changes, and I mean, ask a kid where their milk comes from, and they'll tell you the grocery store. They don't even know that somebody has to go out there and slop around in dirty boots and in order to get their milk. So I fear that that's.
I think I appreciate that, because I've been thinking about one particular neighbor, and I joke a lot about where Senator Campion lives, but out on the West End, used to be a farm called Fairdale Farms, huge farm in Bennington.
Yeah.
And, over the years, they sold out to Garlic and then, eventually ended. So one person has a large wedding venue and other types of activities where the farm was in the building. It's called the Hubble Homestead. That's big. And then the other guy is leasing the land to do some farming operations. So if on a Saturday morning in June, the Hubble Homestead is holding a wedding and the farmer decides to spread manure, there's a battle between these two businesses. That is totally understandable. I mean, if I'm paying thousands for my daughter's wedding, I certainly don't want it interrupted. And I'm not sure how well they all get along. And then there's another neighbor up there who, not Senator Campion, but there's another neighbor who confuses it all. And I'm thinking, oh my God, if we pass this, what happens to that whole situation? So, I don't think much, but one thing I do have a question about is water quality. And if we pass this as it's written, we know there's arguments between A&R and agriculture, the Agency of Agriculture, over water quality issues. If we pass this, where would that stand?
I don't think it will have much, if any, effect on the relationship between the two agencies. The structure of the state's water quality, agricultural water quality law vests significant authority with the agency of agriculture, but the agency of natural resources is the ultimate regulatory authority over water quality discharges, the quality of the lakes, the quality of the rivers, and multiple other water quality laws. That's why there is a memorandum of understanding between the two agencies. Doesn't mean that they always agree on how that MOU should be implemented, but you have imposed a framework and conditions on how they're supposed to interact. I don't believe this law will affect that at all. Their regulatory authority, regardless of who is the ultimate one, will still remain.
So another thing that some states do, if they are concerned about that, and I agree with Mike there, but another thing that states do, so for example, New Hampshire has in their right to farm statute 432:35, nothing contained in this subdivision shall be construed to modify or limit duties and authority conferred upon the Department of Environmental Services under revised statutes annotated 485, which is their water code in New Hampshire. So it is not uncommon for states to put in specific disclaimers saying all state environmental law, this does not affect any of the state environmental laws.
Well, we've come to the witching hour. That's from the NFL red zone, by the way. Wins become wins and defeats, it's the witching hour on the NFL red zone. There's same time.
Oh,
It's the witching hour when
NFL.
wins become defeats, defeats become wins.
Okay, got it. I thought you said NFL, and I'm thinking, who's
NFL.
NFL?
Well, I realize that, but the mask is, so
Okay.
I'm inclined to support Senator Baruth's position, but I'm also cognizant of the fact that, this is an issue that we should probably look at in the future and continue to look at, but given the date and crossover and the issues, I appreciate Senator Benning raising some of the issues about these, what happens if. I think you really nailed it. This takes an awful lot more, I think, from us. I wouldn't mind, and I'm also concerned about an ongoing lawsuit. I wouldn't mind looking back at this if I were here next year, after the lawsuit is settled. That may be instructive in terms of what the court says.
Well, following in Senator Baruch's stating his position here, my position is that I would vote for it.
Well, is there a way for something to be put in that it would make sure that it comes up?
Well, I mean, we can always take the miscellaneous judiciary bill and ask legislative council to report back on the status of that suit, plus work with the National Agricultural Law.
You also have the option, the miscellaneous agriculture bill is in Senate Agriculture right now. It's already passed the House. So if you wanted to confer with the chair of Senate Ag regarding the status of this and further action, future action, I think that's an option for you as well.
Okay. I would prefer to wait until the lawsuit settles. I think that might be instructive, but a lot of times the Supreme Court gives us instructions.
Mr. Chair,
Yes,
I would just suggest that if we're going to require a look at this after the lawsuit is settled, which I think is a good idea, I would advise against putting it in the miscellaneous agriculture bill, because I think we would find that it would expand as it moved along through the process.
yeah, I actually have a great vehicle for it. It's called the miscellaneous judiciary bill. Everybody has a miscellaneous bill. So if you and I could work on
Yeah.
the language for the miscellaneous, Eric Fitzpatrick is the draft for the miscellaneous judiciary bill. This is definitely judiciary issues. And to look at the suit and what some of our neighboring states have done. Maybe it's strengthening the zoning laws so that when municipality zones an area as agriculture, has certain rights that other areas don't.
That authority already exists, but as I noted, it's not often or not always implemented the way that.
Well, why don't you and I confer with Eric and see what we can do with it, and put it into the miscellaneous judiciary.
And then certainly would get the, be looked at by two committees.
Yeah.
If when it came up again.
Yeah, it could be reported back to both committees.
Can I just ask, why was there a best practice with respect to what you call vector?
So generally, for most farms, no. That the large farms do have odor, noise, vector provisions, but medium and small do not. There are mitigation measures that the Agency of Agriculture can work with. But there's nothing built in as a standard or requirement for the small farms.
Kind of frustrating to me because I'd like to support the bill, but I feel a lot more comfortable if I knew somebody could be afoul of the agency's own good standing processes. Because I know there's a way to correct the problem. The problem disappears in an instant. So there's got to be something that he's doing to correct the problem, but when he's not bothering to do that, that's when it becomes a real issue.
Well, one thing that you were likely going to, if you haven't already voted on it, you will vote on it soon, is that the Senate Ag Committee has a bill in which the good standing provision is going to extend beyond just water quality, it will be to all agency programs. So that I don't think it addresses all of your concerns, but I think it begins to address it.
Okay. So we're gonna move, thank you, Michael.
Thank you.
We're gonna move to S-127, which is really, rule 74.
Thank you.
I believe that.
Hi, Ed, in person.
Okay. Nice to meet you in person, yeah.
Yeah, nice to meet you.
Yeah.
Right,
I think we did meet somewhere
Yeah,
personally, one of my trips up for the justice oversight.
right, yes.
Remind me to remind you that we have something for justice oversight to look at this summer.
Mr. Chair,
Thank you.
Mr. Chair,
Oh.
I'm gonna drop off now and jump in my car, and I'll be down there I'll miss the hour of this, but I'll be down there and see you all on the floor.
Okay, thank you.
Stop at Maribel's.
All right. We're moving to Rule 74. I believe that, do we have copies of the redraft?
Yes, it said 3.1.
Redraft? Where's that?
It was right on our desk.
Oh, see, I already have a file. That's my problem. I have a file on that bill.
Yeah.
Oh,
Hey,
thank you.
you're welcome.
I'm not used to being
I
in person.
know.
All right, this is a redraft based on some work with Commissioner Demmel and Ben and emails back and forth, which comes a ways, and I think the Defender General may have a couple of amendments that he might want to offer on it, but for our consideration. Why don't we walk through this draft 3.1?
Senator, would you like me to share my screen or just kind of go through them because they're not extensive? It's just.
Well, yeah, do Judge Zone and Matt, do you have copies of this?
I obtained one. Yes, I grabbed one off that was posted.
Yeah, I have it.
Okay, so we don't need to share the screen since Senator Baruth left to drive to Montpelier. Oh my God. The glasses fall.
I know, I can't. And I think I'm gonna have
So
to
you're
grab
all
one
gonna
now.
support getting rid of the rule that we have to wear these masks, right?
I'm gonna grab one like you have, because this one is just too tight, even with the extender thing on the back. Oh, thank you.
It's brand new. I picked it up coming in because I need an extra one later, but I'll go back and get it.
Yeah, my glasses,
It'll still fog up.
well, I know they will, but at least I won't feel like I'm being strangled.
All right. And if you could walk us through the draft.
For the record, Ben Novografsky from the Office of Legislative Counsel. This is draft number 3.1 of the strike call amendment to S-127. The changes in this draft begin on page 1, on line 14. There was discussion yesterday about changing the interrupt period from 90 to 180 days. That's reflected on a change to line 14. Scrolling down onto page 2, again on page on lines 5 and 6, there's also a change, changing the standard from abuse of discretion to clear error, and then on line 6 from 90 to 180 days. And just to take a moment to read it and also explain the clear error standard a bit. So lines 3 through 6 or 7 on page 2 now read that the appellant shall have the burden of proving by preponderance of the evidence that the department committed clear error in imposing a furlough, revocation, interruption for 180 days or longer pursuant to subsection B of this section. And for understanding on really what clear error means, and I think a little clarification from my testimony yesterday may be warranted, is that this isn't, I didn't mean to represent that this is a middle ground between the department's position and the Defender General's position. What this is sort of a middle standard of review between de novo and abuse of discretion. It is still deferential to the agency or to the department's decision in the sense that clear error is that findings must be credible. So if there's any credible evidence to the department's findings, there would be deference to that decision. So it still is a deferential standard, but not as deferential as an abuse of discretion, where really that's the highest level, and it's really where the department totally withheld discretion or exercised it in a clearly unreasonable way. So I just wanted to get a chance to clarify that for the committee so that you understood the difference between the various levels of review. Scrolling down, there is a change on line 10 of page 2 again, where clear error is now inserted. So it would read in the subdivision 2 that an appeal filed pursuant to the subsection shall be limited to determine whether the decision to interrupt or revoke an offender's community supervision furlough status was clear error by the department based on the criteria set forth in subdivision D2 of this section. Subdivision 3 on page 2 remains unchanged. And then again on the top of page 3, beginning on line 1, this is again a change in the standard and also in the time period. So it now reads that it shall be clear error by the department to revoke furlough and interrupt furlough status for 180 days or longer for a technical violation. And that is the extent of the changes contained in draft 3.1.
Thank you. Appreciate that. I particularly like the 180 days. I think that, but clear error, if I looked at yesterday, Matt brought up a case of JB, I believe it's JB. Yeah, JB, who was taking care of his pregnant girlfriend and the pregnant girlfriend's mother, because she had kidney disease and a broken and infected leg. would that be clear error that they didn't take into consideration the need to be there at that particular place?
Well, to be quite honest with you, I have to review the whole case itself to really give a full opinion on it. I think that the reason why this standard exists, though, is that largely the courts defer to an agency's expertise. And so that's why there is a level of deference on a factual finding. But again, there is substantial deference given in the sense that if there's really no credible evidence, then it could change the determination. But if there's any credible evidence that the department made the correct decision, it probably would be sustained.
Because I can just see that situation where the probation officer gets stubborn and says, I don't care. You're not supposed to be there, and you're there. Therefore, I'm gonna, interrupt your furlough, recommend, and I just don't want to completely take away that kind of. Well, seemed to me that somebody would normally say, and I can remember. I don't tell the story. It's instructive of sometimes how probation operates. So I'm away on vacation. There's a kid who's under corrections, locked in his room. He locks himself in his room because he didn't want to meet with the probation officer. He couldn't go any quicker. All I had to do was keep talking to him. But the probation officer got upset with him for locking himself in the room and called the police, and they broke the door down and got him out and took him to jail. Now, there was a lot of ways you could have dealt with this. Now, to make sure that the commissioner realized this is a very old case. This guy is now 65, so he's very old. And the kid, we've remained friends for over 50 years, but I mean, that's the type of behavior sometimes we see. And then the poor commissioners, people are trying to decide whether to back this probation officer or not. And that's why I want to make sure what clear error is.
Well, and if I may too, really it's the level of review that you want to give, that the committee wants to give the court, because right now under the statute, there's sort of what I'm going to term as a de novo plus review, where you can review it anew, but if the court determines that there's good cause, it can take more evidence. Normally, it would just be contained to the record from below. And so as far as the example that you gave, Senator Sears, I mean, it really would be determinative on what is contained in the record that's submitted to the court and whether the facts in that record would be deemed credible under the clear error standard. So, but the court under this, the way it's written right now, wouldn't have the ability to take additional evidence. Because there does exist that clause in the current statute that for good cause shown, there could be additional evidence to supplement the record. I think that's important for the committee to understand, that it really would be right now as written, more deference. There would be, the clear error standard is a lower deferential standard than abuse of discretion, but the court would not have the ability to take more evidence given the current language of the statute or of the bill rather.
Anybody want to comment on that? I will add that he's no longer a kid, obviously. His success was greatly enhanced by winning a lottery.
That's just the way it is.
Matt?
I'm more than happy to comment on it. This proposal is actually more restrictive than what the bill even, as it was introduced, was proposing. When you bring a clear error or a clear in law, we often refer to it as a clearly erroneous standard into the mix. It effectively eliminates all review, except for in cases where essentially there has been a mistake where they confuse a file. So you're talking about one person, but you're putting facts in about another person. And so you have a record that doesn't reflect what the person actually did. So then you have no evidence to support the factual determinations that were made by the department. There was a case that Judge Cashman did a couple of years ago, maybe 10 years ago now, where basically what happened is he confused one file with another, wrote an opinion. It was appealed to the Supreme Court. And when the appellate lawyers got a hold of the hearing transcript from below, the hearing transcript bore no semblance to the findings that Judge Cashman made in the case, and that was a clear error reversal. This is one of the cases that I was involved in the 2013 or thereabout, talks about the standard for clear error or clearly erroneous is that the findings of the fact finder, that would be DOC in this case, must be affirmed if there is any credible evidence to support them, and it doesn't take into account mitigating evidence at all. The two ways that this standard is applied is that the standard to overturn the fact finder requires that DOC's decision have no support in the evidentiary record to support factual determinations that are made by the department. That doesn't mean that that means there is no weighing of mitigating evidence, no consideration of anything that a defendant might say, or what the length of the sanction is. What clear error requires under the law is that there be any evidence that supports the decision that the Department of Corrections was making. So anything else that is in the bill regarding 180, the 180 days, the length of the sanction or the like means nothing if the factual basis for it is upheld. Effectively, this really would put us back to a point where we were before Justice Reinvestment 2, where the decision was unreviewable. And I also take issue with the concept of what is usually done when you're talking about de novo review. What is usually done under Rule 74 is the legislature prescribes what the elements are that need to be proved so that for the court to make a determination. Rule 75 is the plain abuse of discretion standing or a standard that is out there. The question is, what is a court allowed to hear in reviewing the decision of the Department of Corrections? And we have long believed, and we have not had a case that has been well preserved enough, that the Department of Corrections has been violating the Morrissey v. Brewer case for a number of years. And because Morrissey is this case that is a due process rights case regarding parole cases and pre-parole cases, where it indicates that someone who is on furlough must have the opportunity to be heard and show, if he can, that he did not violate the conditions, or that if he did violate the conditions, that the circumstances and mitigation suggest that the violation does not warrant a revocation. The way these hearings work right now, they are very summary. They are very perfunctory. The real question is, that is asked by the department is, did you do what we said you did, without any real consideration of mitigating evidence that would impact the length or duration of the interrupt, and as a result, when these cases there's a finding that yes, there was a violation, then their case staff, to see what they're going to do, they apply their chart, and then out comes a sanction. Most of the time, the inmates, first of all, they're not represented by counsel, so they don't know how to preserve an issue below for appeal if they wanted to. Secondly, those that make an attempt don't do it well. And so when we try to bring these cases have tried to bring these types of Morrissey violation cases in the past, the issues have not been preserved well. And they aren't because there's no lawyer below to assist in developing the record. What Rule 74, as it was passed over a year ago and has been implemented for 1 year, has done is finally given the inmates the opportunity to present mitigating evidence before a tribunal, being the court, to review fundamentally whether or not the department has abused its discretion and has fairly treated the individual, considering mitigating evidence. In our view, this is the first time that since the institution of furlough, when good time was taken away during the Douglas administration, that Vermont has fully embraced Morrissey and allowed the consideration of mitigating evidence. If a clearly erroneous standard was in place during the past year, every single one of the cases that I provided to you yesterday that the court reversed or modified the decision, every single one of those would have failed. Not one of them would have had no evidence presented by the department to warrant what they did. The question is one of proportionality and judgment. And in fact, one of the things that I keep trying to bring up here, and those of you who were in the legislature for the 2 years prior to the current law being passed, you have to understand the circumstances that this arose out of, the issues that the Department of Corrections was having, and that this language that we have right now is the middle ground. This is effectively negotiated language over a long period of time and then debated in the legislature and then passed, that provides a middle ground between full de novo review by a sentencing court and de novo based upon a record with, number one, the ability of the defendant to tell his story, and on occasion, for good cause shown, to bring other evidence in. To me, that what you want to get to is a fair result, and the current system provides a fair result. I understand, as I've said before, that there are some glitches in the kind of administration of the system, but and I think that those can be addressed and have been addressed by the by the certification that it's within the time frame that the and the like, and that so that DOC doesn't have to produce the whole record if it's under 90 days or under 180 days, whatever. And the reason I'm frankly don't care that much about the 180 days is there's a practical matter here. We can't get cases into court in less than 180 days, even if we want to. So someone's going to sit there for 6 months while we wait for a court date. If we could get it into court quicker, I probably would be more reluctant to agree to such a thing.
So other than that, the standard. That's the only place we're disagreeing in this new draft.
The standard is the biggest issue. I mean, that clear error or is basically would eliminate the right of appeal.
You have your hand up, if we could just hear from you, and the committee will need to make a decision about which way to go on this. Commissioner?
Thank you all. Good morning, Nick Demmel, Commissioner of the Department of Corrections. I just wanted to clear up a couple of topics. I think one of the big notions that maybe is not clear, and I haven't done a nice job of explaining, is the record that is sent to the court does capture evidence, witness testimony, and written products from the individual who is interrupted on furlough. And that's something that I haven't been clear enough about. And I want to just explain to you that the department offers individuals to present evidence, witnesses, and other relevant information. And Rachel, if you don't mind putting up, if the committee will allow, we wanted to share with you our notice of hearing form, which an appellee on Rule 74 would have to sign before the hearing, which explains all of the rights and their opportunities to present information for the record. So the record that's being sent to the court does already capture the mitigations that the furloughee who is on interrupt would want included in the court. Just to read you a couple of these, the appellant, the furloughee, has the right to be present and be heard, has a right to present their case, has a right to present documentary evidence, has a right to call the reporting officer or any other available reasonable witnesses, has the right for witness testimony to be provided using alternate forms of communication if the witness can't be present, and the hearing officer does not have an option, but must note the witness's availability through their adjudication. The hearing report also contains a place for the hearing officer to identify the witness and any information and evidence that was presented by the offender during the hearing. And then the furloughee has the right to submit written statements to the hearing officer, and they have the right to request the assistance of a hearing assistant. So this notion that the department is making these decisions capriciously without any input from the furloughee is just flatly wrong. And I just wanted to make that very clear. On the argument of Morrissey, the reason I think that the Prisoner's Rights Office has not been successful in extending the Morrissey decision to Vermont is that Vermont's Supreme Court has said that there is no liberty interest in furlough on 2 separate occasions, and the U.S. Second Circuit Court of Appeals has said in affirming Vermont Supreme Court's decision that that doesn't apply. I just wanted to highlight 2 quotes for you. What that means is the furloughee does not have the same right that a parolee has. And where the Defender General continues to point to the furloughee must have this opportunity to do these things under the liberty interest in Morrissey, that's actually a misstatement. It does not say furloughee in that Supreme Court decision. It says a parolee. And the Vermont Supreme Court on 2 occasions has explained the distinction between somebody on furlough and somebody on probation. So the Vermont Supreme Court held in its first case that status under furlough more closely resembles that of an inmate seeking a particular right or status within an institution rather than that of a parolee. And as a result, no liberty interest in furlough status may be asserted. It then upheld its own decision and further explained that in State v. Green, where it said that one of the defining aspects of furlough is the degree of decisional control over the plaintiff by the corrections department is the same as whether the plaintiff is on furlough or whether they are incarcerated. What the Supreme Court was saying there is furlough is a distinct institution in the state of Vermont that enables the department to put people on release. But those individuals who are out on release are under the department's control, and it is as if they were incarcerated. The same types of rules apply. Now, we would not, the state of Vermont would not step in and make determinations about individuals who are incarcerated and whether specific small hearings within the incarcerative setting would invoke these other rights that we talk about under Morrissey. That's essentially what the Prisoner's Rights Office has tried to do in Vermont courts. They've been unsuccessful there, and Vermont's courts have consistently extended no liberty interest to furlough. And so what I think prisoners' rights is trying to do here is where they've been unsuccessful in the courts, they're trying to expand and create the most expansive and confusing standard for us to apply in the courts so that they can expand the rights that they want to capture from the Morrissey decision, but that the Vermont Supreme Court and the Second Circuit Court of Appeals have said do not apply here. And so the point of that is that they're asking for greater due process rights for the furlough individuals. And while we don't believe that the Morrissey decision applies, and the court has said that, we do provide those furlough individuals with due process. That hearing notice must be signed by the furloughee before the hearing so that they know what rights are afforded to them, that they can present that evidence. But in practice, what the de novo plus standard, as Ben so aptly put it, has allowed is the record is reviewed, the information is provided by the furloughee. If they don't get the result they want, when they go to court, they then say, I have new information. And in that instance, the attorney generals who are defending the department have no opportunity to present counter evidence, to investigate the information that's being presented. So in a case where an individual were to come to court and say, oh, I was actually just helping my mother, she was very sick, all the court knows is that statement. The attorneys general have no opportunity to rebut that statement or present facts that counter that statement. And I'm not saying that many individuals are going out and doing this, but the fact that we've created a standard where only one side gets to present new information when it gets to court creates an unfairness in the system. That's part of the reason that we need a better, clearer, less expansive standard. Certainly, I thought that the error standard that Ben suggested yesterday is one that could work. I thought that was a compromise solution. It appears now that the Defender General is more interested in the abuse of discretion standard. Certainly the department is open to that as well. What we can't have is the continuation of an expansive and unclear standard that is creating disparity in the court system. I reject the idea that the department does not give people the opportunity to present the information that they have. I think it's very clear in our policies and through our practice and through the records that we've sent to the courts that they do have that opportunity.
Okay, I just, for my own sanity here, I'm making sure that the only issue for us right now is the review. Is that correct? Everybody's agreed on everything else. Judge Zone, is that accurate?
Don't know that it is. Tom Zone, Chief Superior Judge. I think that yesterday, Mr. Valerio was also, we were talking about what's the scope of the review? Does it allow, for instance, on the cases that he talked about, the court to review the length? I thought his position was the court should be able to review the length, and the new draft does not provide for that. It would say that the only decision that is reviewable is whether or not there was a basis to revoke, not the length, as I understand the draft. If you'd like me to address the issue of the clearly erroneous, I can touch on that quickly also.
Yeah.
If the legislature seeks to essentially, as a policy decision, make the Department of Corrections decisions unreviewable, the statute as proposed would effectively do that. Clearly erroneous standard requires any evidence. It would remove if there's something there that supports it, that's it. Senator Sears, you've given a number of examples. And what I'm hearing from your examples is that, well, there should be times that people aren't really punished, if you will, quite as much. Clearly erroneous means if you have a judge like the decisions we heard yesterday who thinks, well, no, DOC went far beyond what was necessary to effectuate the purpose. Clearly erroneous means it's upheld. The court basically can't review it. Even under abuse of discretion, that's a very deferential standard to the Department of Corrections. But the clearly erroneous standard, again, is there any evidence? And you view the evidence in a light most favorable to the party who took the action. And usually clearly erroneous is reserved for factual findings. And so with that, that's a real change. So I would not be in favor if as a policy, if the legislature wants to have meaningful review, I don't think you want clearly erroneous. I would
Okay.
also comment, there's talk about this record. Well, if the court, if the defendants, if the individuals, the inmates are providing testimony and having witnesses called, I don't believe the court gets a recording of that. And so the record, if you will, that the department is utilizing is not the same as what the court has. How can a judge say, well, no, that finding was clearly erroneous because the judge isn't hearing what the person at the Department of Corrections heard? They might have documents. We're being told by the person in DOC, this is what was said. But if we don't have the ability to check it, what happens when the inmate says, well, no, that's not what was said. That's not true. The court doesn't have that information, doesn't have this evidence, if you will, on a recording to know what the record was. And so that makes things a little difficult for that type of standard of review.
Okay, thank you. Matt, I know you're anxious to comment.
Yes,
Ben,
just really,
Ben?
in my case, bypass another change to the bill. I did remove on page 2 subdivision. And in subdivision 2, previously it read that the length of interruption or revocation shall not be consideration in the use discretion determination. That was removed altogether, so it now could be a consideration.
Okay.
If I can, I would just offer that I don't agree with that necessarily, because it says an appeal shall be limited to determine whether the decision to interrupt or revoke was clear error. I think a fair reading of that would not allow a judge to review the length, even though it's not stated, because it's limiting it by its very language.
Thank you. Matt?
I wanted to explain the Morrissey situation first. When furlough first came into place, by the eyeball test, clearly being out on furlough looked like a liberty interest, smelled like a liberty interest, looked like a different form of parole, looked like a different form of release. We had a bunch of different, and that ended up being litigated. And once that was litigated, those determinations came out, and basically the Vermont court found that there was no liberty interest in being released from a facility. Go figure. Nevertheless, that was decided over 10 years ago, and since that time, that is what has put us in the position we were. What we are saying is that the current law creates a process because the prior law was wrong and caused problems. The decision under from 2010 that there was no liberty interest after years of issues, and I know that Senator Sears, one of the areas you received the most number of complaints about is the arbitrary use of revocation of furlough over the years, and when that occurred and how that occurred. And that was part of Justice Reinvestment too, and the fact finding that went on there. The process that was created as a result of that effectively put in a Morrissey standard into Vermont to give people a realistic ability to tell their story and to have decisions of the Department of Corrections reviewed. If you want to go back to the old way of doing things, then of course the legislature can do that. But really what is going on here is the department does not want to have these decisions reviewed, because any of the offers that have come forward, the bill has introduced the clear error standard and the like, have effectively said we don't want to be reviewed. What I am suggesting to you is that the current process is not flawed, and while you had one judge, Judge Torr, who issued a decision who said that the language was inartful and was confusing to her, you have a bunch of other judges, Judge Hoare, Judge Mello, who seem to have no problem whatsoever applying the standard as it goes forward. and they know what to do. They look at the record that whatever came from the Department of Corrections. They listen to what the defendant says. If there is any more evidence to come in, they allow it in and they make a decision. That's not hard to figure out.
Okay. Further comments, questions? All right. So where are we at here? So I thought we had a simple little bill here. Yes, there should be some ability for the court to review, but by the same token, where at least the AG's office to review the facts that are outlined. What I'm hearing from DOC is that under the current status, JB comes in and says, well, I was at my girlfriend's house because she was pregnant and because her mother had kidney failure and had a broken leg and needed help getting to the commode or toilet. So I was there, yes, but even though it was against my furlough. So the probation officer seems pretty cold-hearted to violate a furlough, interrupt the furlough based on that. So how does the probation officer get a voice in this? Or in this case, the Attorney General, to rebut what JB has said, whether it's true or not. I guess that's kind of what I see as maybe necessary. Am I on the right track here? Yes or no? Matt?
One of the things that could easily be done is that the Prisoners' Rights Office could file a proffer of facts in advance of the hearing. All it is it's like pre-filed testimony. Basically, say these are the things we intend to present at the hearing, and if the department wants to rebut them by some other evidence, then they can do that or cross-examine. I don't think surprise here is frankly as big of an issue as it's being made out to be. I think that these facts are generally known to the probation officers. I don't think there's a lot of surprise going on here. But there are easy ways to deal with that. Normally what I have provided with you to you about a summary of what the defense cases are, that's about all there is. There's not a lot to it.
Gary, did you want to comment? Gary Margolis. Marvel, I'm sorry. Gave you a new name.
Thank you, Senator. That was a good interpretation of my name. Thank you. No, I would just like to speak to some of the dynamics that are being discussed here. For one, a lot of the information that's brought up during these hearings, and do you need anything from me as far as my title or anything like that, by the way? Sorry, Gary Marvel, Field Operations Manager of the Department of Corrections. A lot of the information that's provided, it would be very difficult for us to be able to speak to, because many of the times with these cases, we have somebody who's absconded for a period of time. And that's actually one of the problems with abscondment, is we have no idea what's going on with someone during that time. We may know through rumors or information that we've been provided where someone's located, but if they're not willing to engage with us, shy of going to their house repeatedly, which we did do, by the way, in the case of JB, which was mentioned. We did that several times over a period of months, which wasn't mentioned by the Defender General. We don't know how to provide any rebuttal to the information that's provided at these hearings, even if we were given the opportunity to, because we're not engaged with the case. And that's what an abscondent essentially is they're not engaging with their supervision. But that is, so it'd be very difficult, even if we were allowed to come and say, oh, this is our side of it, without us having some investigative capacity beyond what our current resources are, to provide information to the contrary of what's being said when someone is allowed to provide additional information to the court in addition to the record that we've provided.
Oh, God. All right. Okay, so there are two open issues. Huh?
Does that include one that Judge Zoney brought up?
Yeah, the issue of the length of the interrupt.
And Senator Hughes, in regards to that, yeah, rather than just removing the express prohibition, I can also include in that subsection, just to say that it is part of the determination as well, that the length would be part of the determination of the decision to interrupt or revoke, to make it clear.
And can we, if we did a strike call, again, draft 4.1, that had the information regarding the issues that the defense, the Prisoners' Rights Office is going to raise, provided to the department. The department makes a good argument that the Supreme Courts have said that the furlough is not a area where, so.
Yeah, and on that point too, from the case law that I've seen, there's one Davey v. Baker from last year. It's just that they've declined to answer the question right now. It hasn't been right for review. But that doesn't mean that the committee or the legislature can't change that. But as far as, I think the Defender General's Valeria's suggestion as, including a proffer of facts with the record or prior to hearing, I mean, that's something that can be added to the procedures to give the court more information for the review if that's what the committee decides.
All right, and then the length of the.
Senator Sears, if I may.
Yes. Yeah.
I'm not necessarily averse to the Defender General's idea about a proffer of facts in advance of the hearing. My only reservations there is that the Prisoners' Rights Office only represents some of these individuals. And so if there was such a structure written into the law, that would only capture a percentage of the cases. Whereas if a furloughee was representing himself or herself pro se, or if they were represented by private counsel, I'm not sure how you would capture those individuals. So I just wanted to flag that for the group there. And then on the issue of length, certainly I think it was the intention in the changes here today to capture the length, because we heard clearly from the committee that was their interest. And it wasn't, while I agree probably with Judge Zone's assessment that it wouldn't be captured in here, that wasn't the intention of the edit there.
So where are we at? That's something we can live with. We can look at it tomorrow morning.
I have no idea.
You have no idea if we can live with it?
I'm so confused. Very confused, but yeah,
Okay, well,
we should take a look at it. Yeah, we should.
yeah, I don't. We tried in Justice Reinvestment to reduce the amount of furlough interrupts, because they were seen as somewhere in the neighborhood of 60% of the new admissions, and maybe off by 10% by the Justice Center's calculations. So we set out to change Rule 74 to allow the review of interrupts, and we set on 90 days. Now we're learning that the 90 days that is included in that it takes 6 months to get to court anyway. And so after, there's not much point of looking at things under 6 months. So we changed the 90 days to 6 months because it's not going to make a heck of a difference. Second issue becomes the length of the furlough interrupt. Taking the guy who's got a 4-year interrupt and the court finds that there should be a 2-year interrupt. That's fine, but what does the court base its decision to make it a 2-year interrupt on? Does it base its decision on whether there was an error or not? And we've all been in social services long enough, or legal fields long enough to know that they're human beings, they make errors. I can remember reading a pre-sentence investigation on a kid and going over it and saying, oh my God, he's got the wrong kid. All the information was somebody else. So, I mean, errors do happen. So that's all you could base it on under what's in draft 3.1, as I understand it. The choice here would be to allow for a review of the case, de novo, of the facts, but to provide some of those facts, like in the JB case, that he was at home, allow the Attorney General, whomever, to know what the basis is of the case, whether or not it should be interrupted, whether or not, what's the length. Presumably, it's already been interrupted for about 6 months, because if it takes that long to get to court, we've already got 6 months interrupted. I think we're down to that. Am I missing anything, Ben?
Well, no, I think that the three things that were discussed is, the express inclusion of the length to be part of the determination.
Yep.
What the standard of review is, and then what, if any, evidence to include in that review. Right now, the current standard is a de novo review where there can be additional evidence provided. If the committee views that that's the appropriate standard, it could just be kept as is. But if the committee wants some level of deference to the committee's decision and the ability to take additional evidence, that's something else that can be worked out. And, I think that I could work with the department and the Defender General's office to get some language that would be, a compromise from their perspectives. And so I'm open to suggestions on that as well.
Well, I'm fine with something of that nature. Really to look at.
To some level of deference, but with the ability to take further evidence.
Am I correct, and just for Peggy, for tomorrow morning's agenda, that this bill, qualified immunity already?
254 is the only thing we have on the agenda for 9 to 11.
Well, then put this on from 9 to 9:30, and since Ben is here on qualified immunity, we'll put that on from 9:30 to 10:45. Okay? This has been interesting to be back, but looking at the wall
I
to
know.
see the witnesses, and it's much more difficult for Senator White because the desk is facing.
Yeah, so Senator Collmore brought that up yesterday when because he said, it looks like I've got my back to the, so people out there think I'm not paying any attention when actually I'm looking at you.
Yeah.
Yeah, it is weird.
Anyway.
Barely you anyway.
Uh-huh.
We know there are people there, but we can't really see anything anyway.
All they're saying is that.
Yeah, because they're so tiny, right? Yeah.
Well, at least you're in your kitchen, Matt. Well, we really don't know where you are. You're covering it up well. For all we know, you're in Tennessee.
With his sheriff.
I'd rather not be in Tennessee, to be honest, but.
So does what you're